500 pages? So this is our policy. Right here, this is our policy. It's 500 pages long. Okay. Read that up and sign that you've read it. Okay. Then what do? Well, they get trained. And they go out in the street, and they got other officers there, and they got a training officer. They got a training officer who says, okay, you've got the policy manual. Okay. I've read the policy manual. This is how we implement what you're supposed to do. These are the tactics that you can use, and these are things you can do, and these are things that you cannot do. So that's how he learns. He's got a big book in the hope to help the community. He's got a big book and a hope to help the community. And then he goes into the streets, and he's got a training officer. And he has a trainer. They tell him, in this circumstance, do that. They have him wear these DARs. They know everything they say. Everything these guys say, they know. So for 10 years, they know what he's saying, what he's doing. They got it right there. That's why they got it, right? They've got these DARs. And he knows they have those DARs. And so what happens? He's out on the streets, and then they train him. Their experience evolves, dealing with people. Dealing with citizens, dealing with criminals, dealing with violence, dealing with people who've been the victim of violence. Okay. So that's how they learn. And it's reasonable that he should be able to rely on how he's trained. I mean, isn't that reasonable? Is that unreasonable? That's not letting the police department set their own standards. That's just like what's reasonable, what's fair, right? They tell him, do this. Don't do that, do this. And so their education evolves. So let's look at some of the procedures that the people put up. You're going to have to skip through this. Okay. So this is the leg restraint policy. It's a written policy. And I'm going to get to the qualifier of all of these, which is you can't predict what's going to happen in every situation. But this is the leg restraint device. Officer Ramos, he's been relieved. Not that he's not there assisting, but his boss is running the show. His boss is running the show, and he's told, and he can reasonably rely that his boss is making these judgments. The officer should look for signs of labored breathing and, where practicable, take appropriate steps. He's not in charge of that aspect of it, is he? He's at the other end of Kelly Thomas, and he's doing what he is been trained to do. And the prosecutor rightfully conceded that Craig wouldn't know what had happened before and that his response was reasonable. Craig's response was reasonable, right? And it was. So what the people want you to believe is that Craig's response was reasonable. He's fine. But Ramos's reliance on Craig is murder. Now, that's just not right. Ramos's reliance on the reasonable sergeant is criminal negligence. It's not. He's entitled to rely on his sergeant. His sergeant has control of the scene. And so all this stuff about he should have done this, he should have done that, he should have stopped this, he should have stopped that, he should have intervened, he should have said, I think maybe Kelly Thomas misinterpreted my admonition. Nonsense. The sergeant, all that stuff, he should have done this, he should have done that. The sergeant is in control. So that's this. And this labored breathing, we've already talked about that. We've already talked about that. Mental illness commitments. Mental illness commitments. So he was negligent, and that leads to murder. He should have done something. He's an unprofessional cop. Well, there's no evidence that Kelly Thomas was mentally ill, all right? We know, and I went through this yesterday, we know that Officer Ramos didn't believe he was. He made inquiry. Kelly Thomas says, I'm an alcoholic. Alcoholism, that's my problem. And they understood one another. They spoke back and forth. There was some, games playing. But he didn't believe that Kelly Thomas was mentally ill. He didn't believe that. And he said so. He says, I don't think you're as you pretend. I don't think that. And then we have that part where he's saying, oh, well, he's mentally ill, but I've talked about that too. He did it to get him out of cuffs. He said it. He's already told Kelly, I don't believe it, but he said it so he could assuage the security guards who'd cuffed him up. That's all. So what are you supposed to do? Even if you thought that he was or might be, what are you supposed to do? Well, one other thing. Corporal Rubio saw how Kelly Thomas acted. He saw how he acted. You can be darn sure he knows the policy, and you can be darn sure he trained Manuel Ramos. Okay? So, what about A? Any available information might assist in determining the cause and nature. He asked him and got told twice on 2 separate occasions, I'm a drinker. Conflict resolution and de-escalation techniques for potentially dangerous situations. What they do that night? This seems like conflict resolution. Not too much to ask either. Give us your name and your address. Your address. Give us your name and your date of birth. You're going home. Just please, just give us your name. They're seeking to avoid confrontation, and that's what Officer Ramos did in the 6 other meetings. He did try to and did avoid confrontation. He did do that. Appropriate language usage. Well, there's a dispute over that, whether the F word is appropriate in this circumstance. But what we do know is that the baton reference worked previously, and by worked I mean de-escalated the situation, and he knew that. And finally, the policy, and this is, the prosecutor put the policy up, portions of it, but you ought to look maybe at how the policy describes the policy. And it says, any interpretation of reasonableness must allow for the fact that police officers are often forced to make split-second decisions. No kidding. In circumstances that are tense, uncertain, rapidly evolving about the amount of force necessary. Well, that's right. It's good not to forget that. Given that no policy can realistically predict every possible situation an officer might encounter in the field, it's recognized that each officer must be entrusted with well-reasoned discretion in determining the appropriate use of force in each instance. Nothing in this policy requires an officer to actually sustain physical injury. So what the prosecutor is saying is not only did these guys, are they out of policy? Of course, there's no policy that they violated. Not only that, but they were negligent. And not only were they negligent, they were criminally negligent. so different from an ordinarily careful person, it amounts to disregard or to human life or indifference to the consequences. It's not that. Okay, so those are the policies. Now, so the policies, they don't help them criminalize this statement, okay, this threat. They don't help them. And so they bring in, who do they bring in? They bring in an expert, John Wilson. They go 3,000 miles, not an expert from Fullerton who understands this situation, what the community is, what the needs are here. They don't go to Fullerton for their expert, and they don't go to Orange County, and they don't go to California. They go 3,000 miles away. The only guy they call is 3,000 miles away, and he is an expert. Well, he's no expert at all, right? He's never qualified as an expert on the use of force and testified in a case before now. Never. This is the first time, and I would venture to say, after his performance, saying that Kelly Thomas could shoot these guys, it's his last. He's not an expert. He's never testified before as an expert. He never will again. This is a guy who never worked the street patrol. He never carried a baton. He never saw a taser being used. He never called for a Code 3 or responded to a Code 3. He never saw a taser, not used it, saw a taser deployed. This guy was an accountant. He arrested bank presidents for fraud, not bank robbers, for robbery. This guy was no expert at all. And you can compare his training, experience, and knowledge of this kind of circumstance. Just you could compare it like to Officer Rubio. And we'll talk, or Corporal Rubio. We'll get to that in a second. But what does Wilson say? So we can sort of clear up, I want to clear up the run-up to this on what Officer Ramos could and couldn't do by their expert, okay? Because this is where this is where he parts company with us. But watch what he says about what was okay. And I'm going to read the transcript. I know it's boring for you, you've heard it, but I want to make sure that we get it right. All right. So Officer Ramos was entitled to direct Kelly Thomas to sit down, right? Yes. He was entitled to control the situation, right? Correct. He was entitled to have Kelly Thomas do as he was told. Yes. Now remember this, I'm talking about this run-up. Everything that Officer Ramos did all the way up to this, that's okay. Okay? And even this is okay except for the language. But that's why I'm reading this to you, so you will understand that everything that he does up to this part is okay. So he was entitled to tell him the consequences of not complying were correct. That's a tactic I think is an effective one, right? Officer Ramos is doing what he's entitled to do and actually what he must do, right? He's got to contact this guy and he's got to do his investigation, right? Answer, correct. He's got to control the situation. Yes. And the first rule of your paradigm is officer safety. Right? Correct. It was a lawful command to sit down there and put your hands on your knees and your feet out. Right? Now remember, that's right up at the point where we're going to get to this statement. It was a lawful command to sit down here, put your hands on your knees and your feet out. Right. That's all lawful. That's all officer safety. Right? Answer, correct. It doesn't have to do with whether this is a car burglary or receiving stolen property. Once he has control of the suspect, the officer decides He must be able to decide what is necessary at that point for officer safety. Correct. That's what I was telling you before. This is not about, the prosecutor makes it sound like, well, this is just about a piece of paper they got taken out of the garbage and a receiving stolen property. It's not about that at all. At this point, and their expert says this, at this point, it's about officer safety, and Mr. Wilson agrees with that. It doesn't have to do with whether this is a car burglary or receiving stolen property. The officer must be able to decide what is necessary at that point for officer safety. There's no dispute about that. Their witness confirms that. And if he can do that with words, it's far preferable than using force. Answer, that's correct. And so then I asked him, well, this threat, you don't like this threat, but are you saying it would be okay if he said, Mr. Thomas, if you don't do that, I'm going to have to use physical force in order to make you do it. Correct, I have no problems with that. So what we're talking about is delivery. That's what we're talking about. And by the way, and I wrote this before, said this before, regarding the baton, it was a good tactical choice to refer to his baton. You know, this threat with the baton. I don't see a problem with that. So the fact that he referred to using physical force, the baton, that was okay in the earlier encounter. It was reasonable, yes. So just so you have in mind and you recall, that baton threat, that was reasonable. Not only was it not murder, manslaughter, criminal, out of policy, it was reasonable. Okay, so if I go like this and say, you've been hit with one of these before, or if I point to my baton and say, have you been hit with one of these before, with the clear implication you might get hit now if you don't do what I tell you, if I do that, if I use this baton in this way, the reference to this baton in this way, the words about this baton in this way, that, by their expert, is reasonable. If I do this, you see this fist, that's murder. Reasonable murder. That's what he said. Now you have to decide whether that makes much sense. You have to decide whether this, and that's their expert. That's not us. That's their expert. Their expert says, this is okay. This is not okay. Does it make any sense, that? That distinction, does it make any sense? Does it make any sense at all? No. That's okay. When Kelly Thomas moved his hands, after this threat, when Kelly Thomas moved his hands off his knees, remember what the Wilson said. That was, he was authorized to do that. He can tell him to do that. He has a right to tell him, keep his hands there. When he moves his hands up, this is after this alleged threat. After Kelly Thomas says, start punching, dude. When he takes his hands up, Officer Ramos has the right to have him put his hands back down there. In the force used, look at it on the video. He starts to move his hand. He points. This is where your hands go, pal. And he starts to put them down, and then Kelly Thomas gets up. He had the right. Even Wilson. Because Wilson says, I can't, you know, and here's the other thing about Wilson. He says, oh, I can't really evaluate this because this was wrong and everything after that was wrong. Okay, well, how about if this wasn't wrong? Once Kelly Thomas got up, which he had no right to do, no lawful right to do. Nobody would believe he has the lawful right to get up at that point. Nobody would believe that he has the right to take his hands off his knees while he's being lawfully detained. The prosecutor says, well, put yourself in Kelly Thomas's position. A reasonable person in Kelly Thomas's position. Well, that's kind of hard to do, right? A reasonable person wouldn't be in that situation. A person who had acted reasonably wouldn't be there. And it's hard to get inside the head of somebody like Kelly Thomas and say, well, how would he react to this statement? But you don't really have to do that, do you? Because you know how he reacted. His reaction was a sarcastic remark, start punching, dude. So, all right, Officer Ramos had the right and the responsibility to show him where to touch. And he had the right, when he started to get away, to pursue him and to attempt a leg strike with the baton, a leg strike. He had the right to restrain him, and he had a right to call Code 3 when they couldn't control him. None of this stuff is sort of, not only is it not out of policy that you've seen, it's not out of training, and it's reasonable. All of it is reasonable. We know that he had the right to do this. We know that's true because Mr. Wilson, we know what I just said, we know that's all true. And we know that from Mr. Wilson. The prosecution own witness said this. They said a cop in the street is entitled to rely on what his trainers told him. What his training was, he's entitled to rely on that and to do that. Okay? That's what he said. That's their expert. That's their guy. That's the man that they brought from 3,000 miles, the accountant from the FBI, to tell you what's what. And he says, and it's true, they're entitled to rely on their trainers, what they were training. They're entitled to employ the tactics that were consistent with their training, and that's exactly what Manny Ramos did. That's exactly what he did. And they can't get away from that, and that's why they're sort of saying, well, you know, you decide, and Fullerton Police Department can't decide. They're all a bunch, you know. You're talking about what's reasonable for him. And their expert told you he can rely on his training. Okay? So, Corporal Rubio comes in, and what does he tell you? Well, he's the trainer. He trained Manny Ramos. Well, that's like be sort of an important witness to know, right? Their expert says he can rely on him. We've got a written policy, but how is actual work done? How are you to implement the proper rules and regulations? How are you going to do that? From reading a book? No. They got a guy, and they got a pretty good guy, too. They got a guy who was 20 years a cop. 14 of those years, what was he doing? Not arresting bank presidents, I can tell you that. He's walking the streets. In L.A., in Fullerton, he's a street cop. He's an expert in tactics. He knows that he's sending out these young men to the streets, not knowing if they're going to come home at night. They don't know if they're coming home. He doesn't know if they're coming home. Knowing that they have to do the right thing, knowing that they have to be within policy. And so Fullerton PD, they assign somebody. They assign somebody to say, okay, here's the manual, but Officer Ramos, you listen to this guy, okay? You listen to him. You'll be all right. You'll be safe. The community will be safe. You won't be violating any law. You're doing it pursuant to, what you're taught. That's what happens. That's what happens. So Corporal Rubio starts being a trainer in the use of force in June of 2006. He stops in July of 2013. Okay? So some events occurred between that time, right? Well, we have this event, so that's in between. So we know that he's the trainer after this. He's the guy who sent these guys into the streets with the knowledge and the responsibility and the training on how do you deal with the situation. He sends everybody, those guys out. Well, after the event, he's a trainer for 2 more years. 2 more years. In the meantime, a year before this, he's interviewed by the district attorney. The district attorney. And he tells them, hey, this is how we train. I'm not talking about, and the judge struck the few words he said about policy. We're not asking to consider that. What remains, though, is really the heart of it. And that is, how are these guys trained? His testimony was on the training. The training that Mr. Wilson said could be relied on. Okay? He looked at the entire video. And what did he say? And remember, he's got much more experience than Wilson. But nonetheless, here's this guy who has probably the most important job in the department, right? Really? He needs to be the most experienced and probably the most important job because why? He's responsible for these young men and for the community. Of all the guys in the department, they entrusted, and told these guys to trust Corporal Rubio. Okay? You can just imagine. You're a young officer, you're working the streets, and you get told, and certainly they were told this, Manny, Jay, listen to this guy. You know, he knows what he's doing. He has our blessing. And so what does he say? He looked at it. What does Rubio say? He says, well, I looked at the tape, and it's consistent with the training. Forget about the policy. You're not going to consider the policy. And remember, you decide what's reasonable, what's not reasonable. Okay. But that should be informed by, like, evidence, right? Evidence. And the evidence is what Rubio said. I trained him. It's consistent with the training. I looked at the whole thing. It's consistent with the training. Oh, boy, they don't like that. They don't like that. And you can't blame them. You know, here's the thing. Here's the thing. The prosecutor talked to him like a year ago. A year ago. And they didn't call him as a witness. Now, he's not fired, okay? I mean, he's still the trainer. He talks to the DA. The DA, you got to believe, knows exactly what he's going to say. It's unhelpful. It's really kind of unhelpful for them. So they decline, omit, decide, we're not calling this guy. For reasons, for obvious reasons. They're not going to call a guy who says what Rubio says, who stands in the position that Rubio stands in. They're not about to call him. Then you'd know. Then you'd know. But you know now. And you know another thing now. They've known for 1 year. They've known before this trial started. They've known before this trial started. And they certainly knew when he testified how these guys were trained. Do you think that the district attorney who went 3,000 miles away to get the only guy, the only expert who testified 3,000 miles away, do you think if there was a single person who could rebut what Corporal Rubio said in the world, in the Fullerton Police Department, they'd have brought him in. Hey, if Rubio is lying, we didn't teach him this way. Don't you think they bring somebody in to say, he's wrong? That's not how we teach him. He's lying. That's not how we teach him. He's mistaken. That's not how we teach him. If there was any rebuttal to Corporal Rubio, they'd have had him here just like they got the doc from UCLA, just like they got the FBI guy from the East Coast. They'd have got him here in a minute. They're not sitting here. You know why? Because they don't exist. Mr. Wilson told you, the street cop, that'd be him and him, he told you that the street cop is entitled to rely on his training. Corporal Rubio told you that their actions, Officer Ramos's actions, were consistent with his training. And nobody disputes that. So, he listened to the alleged threat, and of course you know it's not that it was conditional. You know all that. But he listened to that, he saw what happened, and he said, it's consistent with our training. So now it is that the prosecutor, not witnesses, not evidence, the prosecutor says, well, any reasonable person is likely to know, any reasonable person would know, not guess, not know, it's likely to happen. Well, that's not so. Every police officer who trained under Rubio, you got to assume they're reasonable people, right? No reasonable person. Some reasonable person did say that. And you know what? He didn't lose his job. He's still training. You think for a second, if this training is criminal, okay, do you think for a second that he's the training officer 2 years later, after this event? You think maybe they might have talked to him afterwards, you know, like a lot of people talk to him? So we know there were no acts or omissions by Manny Ramos that were a substantial factor or that caused, that was a natural, probable consequence, and that he would, the reasonable person wrote. So it's not a substantial factor, and his actions or omissions, things that the prosecutor said you should have done, that's not, the result was not what happened, was not the direct, natural, probable consequence. And that anybody would know that. Any reasonable person would know that. So that makes him not guilty. Also, and this is excusable homicide, even if he did cause it, which he did, but even if he did, this is the instruction. The defendant is not guilty of murder or manslaughter if he killed someone as a result of accident or misfortune. His killing is excused and therefore not unlawful if the defendant Ramos was doing a lawful act in a lawful way. Well, he was. All the way up to the alleged threat, everything's okay. We have this dispute, Wilson alone saying he shouldn't have made that statement, but common sense, reason, and his training, he's doing it a lawful act in a lawful way, all the way through. Rubio watched it, watched the whole thing. You did too. He was acting with usual and ordinary caution, absolutely. Nothing that disputes that. You've seen Vilk, you've seen the other, you know that evidence. And he was acting without any unlawful intent. What's the unlawful intent? He had no unlawful intent. He tried his best to send Kelly Thomas home as he had 6 times before. It didn't work this time. A person acts with usual and ordinary caution. A peace officer who has been given these instructions and who everybody agrees has the right to follow those directives. Okay, so a reasonably careful person would act under the same or similar circumstances. The answer is yes, and what does that mean? The people have the burden of proving beyond a reasonable doubt that the killing was not excused. They have the burden. I don't have to prove this is true. He has to prove it's not true. And he has to prove it's not true